Nobody should be afraid to publicly express themselves about public interest issues, especially living in a place like Canada. Imagine if grocery store chains could use lawsuits to prevent people from expressing outrage at our out-of-control food prices, or if people were afraid to publicly name businesses that scammed them because they were worried that the business was going to sue them. Fortunately, in Ontario, just like in America, we have something called anti-SLAPP laws, which prevent that kind of thing from happening to people. The acronym SLAPP stands for Strategic Lawsuits Against Public Participation. I'm Ryan Keeney, and I'm a lawyer in Ontario. Let's talk about how this works. I'm going to read you a bit of wordy legal jargon for about 5 seconds, but don't worry, I'm going to explain what it means in plain English afterwards. Subsection 3 of Ontario's Courts of Justice Act says that on motion by a person against whom a proceeding is brought, a judge shall, subject to subsection 4, dismiss the proceeding against the person if the person satisfies the judge that the proceeding arises from an expression made by the person that relates to a matter of public interest. Some of you might have already understood that section of the legislation, even though people don't usually talk like that in everyday speech. In other words, it basically says that if you get sued because you made an expression that relates to a matter of public interest, then you can tell a judge to throw out the case by simply filing something called a motion, which takes place long before any expensive and time-consuming trial has to take place. There are some exceptions to that rule, but I'll get into those in a moment. For now, it's important to keep some legal definitions in mind regarding the words public interest and expression. The Act says that the word expression means any communication, regardless of whether it is made verbally or non-verbally, whether it is made publicly or privately, and whether or not it is directed at a person or entity. It's basically intended to cover any type of expression. The definition of public interest is a bit more complicated. After all, do you think celebrity gossip is a matter of public interest? Sure, celebrity gossip might be interesting to the public, but it is not typically seen as a public interest issue. The Supreme Court has said that public interest matters are things that the public has a genuine stake in knowing about, which ranges across a variety of topics. As a lawyer, I can tell you that there doesn't appear to be a fixed list or narrow definition of the phrase public interest, and that's a good thing for people who get sued for expressing themselves about public interest issues. Okay, let's get back to those exceptions I mentioned earlier. If a person brings a motion to have a case thrown out because they believe that they are being sued for expressing themselves about a public interest issue, the person or company who sued them can still win the motion and continue the lawsuit if they can prove all of the following 3 things. First, there are grounds to believe that the lawsuit has substantial merit. In simpler terms, this means that the case against the defendant is pretty strong, ignoring the public interest angle. Second, the defendant has no valid legal defense to the lawsuit other than the public interest expression angle. This is honestly a pretty tough thing for an angry plaintiff to prove, because in almost all lawsuits, there is usually some kind of defense that the defendant can argue. It is rarely the case that defendants can come up with absolutely no valid legal defenses whatsoever. Okay, let's move on to the third and final thing the plaintiff has to prove to potentially win this motion and not have their lawsuit thrown out. It is basically as follows. The harm likely to be, or already has been suffered, by the plaintiff as a result of the expression is sufficiently serious that the public interest in permitting the lawsuit to go forward outweighs the public interest in protecting that expression. That last one was a bit wordy, but to put it in really simple terms, although it is important to protect free expression when it comes to discussing public interest issues, it is also important to society that people can seek justice. There is a genuine public interest in allowing lawsuits to go through the courts so that people can get their day in court. When you think about it like that, I'm sure you can imagine situations where judges have to balance whether the public is best served by throwing out the lawsuit and letting free speech win the day, or if the public is better served by letting this specific plaintiff get their day in court to try and prove their case against the defendant. There is some interesting case law from the Supreme Court of Canada where the final decision in each case has gone either way, but I want to keep this video as short as I can, so we'll save those stories for another day. If you're interested in hearing about those cases, then leave a comment on this video asking about that, and I'll put together some of those stories for you. If you found this content interesting and educational, then don't forget to hit that like and follow button. I'm Ryan Keeney, and thanks for watching.